Well, good morning, everyone, and thank you for joining us for a roundtable on special needs trust and ABLE. My name is Rachel Fackender, and I will serve as the panel moderator today. I am joined by a team of experts and advocates who will shed light on special needs trust, coordination of government benefits, letters of intent, advanced directives, and ABLE accounts. Our expert lineup includes ABLE United Director John Finch, Florida Bar Board Certified in Elder Law Stephen E. Hitchcock, who brings more than 15 years of expertise, and Wells Fargo Senior Vice President and Senior Special Needs Trust Advisory Specialist Melissa Barnhardt, who has served the disability community in numerous capacities over the last 29 years. Thank you all for being here today.
Thank you.
So before we jump into the presentation, we're going to go ahead and run a very quick poll to see how familiar our attendees are with ABLE United. So we'll give everyone about a minute to answer, and then we'll share the results. Awesome, seeing those numbers rolling in. Thank you for participating. Okay, so we'll give it about 10 more seconds. Awesome, we're going to go ahead and close the poll now. So thank you all for participating. So it looks like it kind of runs the gamut here. So 10% not familiar, 38% somewhat familiar, so have either read materials or visited our website, 17% familiar, and then 35% very familiar. So love seeing that. So why are we here today? Well, one of the most frequently asked questions that we get when it comes to ABLE accounts is their comparison and how they work alongside a special needs trust. So let's debunk those myths, set the record straight, and dive right in. So John, we're going to kick it off with you. Set the foundation here and shed a little bit of light for our attendees who may be unfamiliar with ABLE accounts.
Wonderful. Thank you, Rachel, and thank you. We had quite a few registrants for today's webinar, so I'm pretty excited that a lot of you are just excited to learn more about ABLE accounts and special needs trust and how they work together and how they're different. So just high level, what are ABLE accounts? And just the basic is they are tax advantage savings and investment accounts specifically designed for individuals with disabilities. And really the history of it started over 15 years ago when families and parents and advocates, just like many of you on today's webinar, sat around and said, you know, why isn't there a way to save for my child for their future benefits without impacting, you know, if they decide to get on SSI or Medicaid and might be eligible for those, to not really put aside funds for them. And so through that and through that hard work of advocates, it passed. The Achieving a Better Life Experience Act is what it's based on. And what it did was create a new section in the Internal Revenue Code, Section 529A. And it allowed states to create these tax advantage savings and investment accounts. Here in the state of Florida, we're under the Florida Prepaid College Board. So the same state entity that helps of millions of families save for higher education expenses is now helping individuals with disabilities be able to save for future qualified disability expenses. And that's what ABLE accounts are for. We'll touch on eligibility real quick. So it's not just everybody that has a disability that qualifies. It is individuals who have a more severe type of disability and a diagnosis that occurred prior to age 26. So this could run the gamut from types of disabilities that individuals might have when they're born, such as Down syndrome, cerebral palsy. It could occur later in life, such as traumatic brain injury, or various mental health or psychiatric types of diagnoses or disorders like paranoid schizophrenia, PTSD, so pretty broad. But the main thing is that the diagnosis occurred prior to age 26, and it is a severe type disability. Here in the state of Florida, our program is administered online, ableunited.com. So hopefully many of you who are familiar or somewhat familiar have visited our website, have an account. But that's a great place to start to get a wealth of information about how ABLE accounts work, specific to Florida's ABLE program and how they manage their account. I'll touch a little bit on how these accounts work with public benefits, and then we'll open this up to others to speak, so it's not the John Finch show. So what's unique about ABLE accounts is that generally funds in the ABLE account and even withdrawn from the ABLE account do not impact government public benefit programs. The biggest two that we see that a lot of people with ABLE accounts have are supplemental security income and Medicaid. Excuse me. For Medicaid, generally funds in ABLE accounts don't count as a resource, so it allows people to remain eligible for ABLE accounts. Here in the state of Florida, a couple of years ago, we were able to pass legislation that clarified some federal language that basically said the state could file a claim on an ABLE account. And so here in Florida, we removed that language and basically stated if a beneficiary passes away and there's any funds left in the ABLE account that can be used to pay outstanding qualified disability expenses, and then any leftover funds would go to that individual's estate. And now their state and how that's settled, there may be Medicaid recovery, but that's a different topic. For supplemental security income, once again, these allow individual ABLE accounts allow people to save more than that $2,000 without impacting that SSI check. There are some additional restrictions, though. For example, retaining funds for non-qualified or for housing-related expenses past the end of the month would count as a resource at the beginning of the next month. So just be wary on how you use your ABLE account. And it's also restricted on how much funds could be in here before it starts counting as a resource, and that's $100,000. But luckily, people contribute up to $15,000 per calendar year into an ABLE account. It usually doesn't count as income towards the individual. People that are not worried about that asset limit of $100,000, they can let these accounts get to $418,000 before contributions are no longer accepted. But that is high level what ABLE accounts are. But hopefully that's a good foundation for where we start.
Absolutely. Thank you, John, for that overview. So I'm going to kick it over to Stephen now. So Stephen, let's come to you to explain what a special needs trust is.
Okay, well, thank you very much and welcome to everyone, and thank you to ABLE United for having me here and speaking today on this panel. Before I discuss what a special needs trust is, let me take about 30 seconds to discuss what a trust is. A trust is, for our purposes, an arrangement where one person, the trustee, is holding and managing money or assets on behalf of another person, the beneficiary. So we have that relationship between the holder of the money, the trustee, and the person who the money is intended to be used for, which is the beneficiary. That arrangement is dictated through a trust document that's created by lawyers, most generally. And the terms of that relationship between the trustee and the beneficiary are dictated in that trust document. Now, a special needs trust is a very particular form of trust wherein it is understood that the beneficiary has a disability and is most generally seeking some kind of needs-based governmental benefit, SSI, Medicaid, maybe Agency for Persons with Disabilities benefits or something like that, where assets are counted. The assets held by the trustee in a special needs trust, and that's that as long as the terms of the trust say this, are not counted as an asset of the beneficiary for the purposes of determining eligibility for needs-based governmental programs such as SSI, Medicaid, Agency for Persons with Disabilities benefits, etc. So we have a trust where one person's holding the money. It could be an individual, it could be a corporation like Wells Fargo. They're holding that money for the benefit of that disabled beneficiary so that that beneficiary can be eligible for needs-based programs like Medicaid, but also have the benefit of that asset, that money for them for their needs.
Awesome. So Stephen, tell us a little bit about what the different types of trust are. So from a first-party special needs trust to a third-party special needs trust.
Sure. And the million-dollar question there is, whose money is it in the trust? If it was the disabled individual's money going into the trust, they own the money and they put it into a trust. That is what is known as a first-party trust. It is first-party money. It is the individual with the disability's own money going into that trust. That type of trust has very distinct required language under federal and state law. A third-party trust, special needs trust, is money that was someone else's that was designated for this disabled beneficiary. It could have been grandpa who left money in a trust for a disabled grandchild. It was never the grandchild's money. It was always grandpa's money, and he left it for that disabled child or gave it over to that disabled child's trust. That's third-party money. That's a third-party trust. And we have to be very careful, the lawyers in particular have to be very careful which type of money was it, because the type of trust has different specific terms that we don't really have time to go into today. But that's the basic difference between a first and a third-party special needs trust.
Awesome. So the number one question that we get, John and myself, is what's the difference between a special needs trust and an ABLE account?
Okay. There's a couple significant differences. There's a lot of differences, but the biggest differences are an ABLE account is owned legally by the disabled individual. It is their brokerage account managed under ABLE United, but it is their money. It's their account. They own it. They don't have to go to a trustee and ask for money. They have full control. Either themselves or their representative has access to those funds directly, versus a special needs trust is held by a trustee. The beneficiary does not have direct access and control to that money. And that's what has to happen in a special needs trust. So that's the significant difference. Difference number one is that the beneficiary owns the ABLE account, and they don't technically have control over the special needs trust because it's in the hands of a trustee. Another significant difference is probably, I'll split it into two differences that I'll go into very briefly because I know others probably will be discussing this in more detail later. John alluded to the amounts of money that can be held in an ABLE account. You can, how much can go into an ABLE account on an annual basis is currently $15,000 with a little bit of an exception that I believe Melissa's going to talk about. And then how much the cap can be at the $100,000 level, et cetera. And I won't reiterate what John said a few minutes ago. A special needs trust has no caps. There can be any amount of money into the millions of dollars in a special needs trust. And there's the sky's the limit from that standpoint. So the significant difference there is how much can really be administered under an ABLE account versus under a special needs trust. And the third difference is what happens when the individual who owns that ABLE account passes away versus what happens when an individual passes away with a special needs trust. And what many of you may have heard of as the Medicaid payback provisions that are required. And we'll be discussing those here in a few minutes. Back to you, Rachel.
Thank you for that, Stephen. So if someone were to come to you already having a special needs trust, why would you recommend that they also open an ABLE account?
Well, I think there's going to be a lot of discussion about the whys, but in a very succinct way of saying it, I hope, the opportunities for use of the money out of an ABLE account, both in access directly by the beneficiary and what the money can be spent on without it being disqualifying to the beneficiary, is different than what it can be spent on coming out of a special needs trust. And many times we mirror those and blend those together where you have both. The special needs trust is there and also an ABLE account. And in many cases, money comes from the special needs trust to the ABLE account to be then utilized through the ABLE account because it's more beneficial to the beneficiary that way in terms of government benefit eligibility and the options for use of the money. We'll be getting into some more of those details as we go along, I think.
Absolutely. So for the next two questions, Melissa, John, I'm going to let you guys tag team a little bit here, but Melissa, can you explain the difference between who oversees a special needs trust and who oversees an ABLE account?
Sure, I'd be happy to do so. So as Steve mentioned before, a trust is a document. It's similar to a contract. And the contract then is overseen by the trustee of that document. So for the benefit of the beneficiary, as was mentioned earlier, in a special needs trust, that is somebody that has some form or is living with some form of a disability. Versus the ABLE Act account, it is either the account owner who has control of that account, the authorized signer, and sometimes also that could be a guardian or a agent under a durable power of attorney. And I just wanted to add one thing to what Steve said as to some of the reasons to have the ABLE Act account. And to me, the biggest thing is the whole reason, from my understanding, is why ABLE Act accounts came about is because it promotes independence for individuals. And that's really in the definition of a qualified disability expense, anything that increases the independence of that individual to allow them to live their best life possible, even though they might be living with some form of a disability.
Right. So John, I'm going to let you take this one. So is the trustee responsible for funding ABLE? If so, what kind of oversight will the trustee have on the ABLE account?
That's a good question. So really, when you're setting up an ABLE account, there is some flexibility on who oversees that account. It could be the beneficiary for themselves, if they're capable enough to, or it could be a third party, whether that be a parent, a power of attorney, or even somebody that has guardianship. In some cases, it may be a trustee. And so just depending on how that relationship exists, now it's up to that trustee and if it's a third party and how, I'll let some of these attorneys handle how that paperwork, that contract is established that allows distributions from a trust to an ABLE account. But often we see a lot of our ABLE accounts are receiving systematic funding from a third-party special needs trust. And so it gives a little more flexibility and a little more ease for the trustee to be able to send those funds into the ABLE account and then it be managed by that beneficiary if they're able to, or that third-party administrator.
Can I add something to that, Rachel?
Absolutely.
So, going back for one moment regarding the trust itself. So under the trust, the trustee has to be guided by the terms of the trust, as Steve mentioned earlier. And basically, special needs trusts, no matter what type they are, they're allowed to be used at the discretion of the trustee for all distributions, that as long as they're going to benefit the individual where benefits or government benefits are not being provided adequately to meet their needs. So that's, pretty flexible standard that we can utilize in Florida under trust documents. Because of that, there's flexibility there, and adding additional flexibility in the trust document to allow for the trustee to make distributions from the trust to the ABLE Act account to increase additional flexibility and access to funds for the beneficiary, once again, is a key detail as to why ABLE Act accounts and trusts can work together. So it's not one or the other necessarily. It can be both joining together and working together very nicely, again, for the benefit of the beneficiary.
Absolutely. So Melissa, let's talk a little bit more about transfer. So can you explain how a child is protected if there are transfers from the trust to an ABLE account?
Okay, let me go back to something that John mentioned earlier. So he stated that for the first $100,000 in an ABLE Act account, that SSI, the individual gets to keep their SSI and their Medicaid. Once it reaches over that point, it might be suspended for a period of time on the SSI side, but the Medicaid continues. And I also want to mention that there's probably several people on this call today where their child or loved one receives Agency for Persons with Disability benefits. That is a Medicaid benefit. So that's separate and apart from SSI. So it's important to understand that to a limited extent for this call today. And for Medicaid purposes, I believe you can have up to $418,000 in the ABLE Act account and still qualify for Medicaid. And usually that's a much more important component for the health care, for potentially in-home services through one of the long-term care waiver programs. such as Agency for Persons with Disabilities. So from a protection standpoint, that's one thing that ABLE account does on its own. And then the trust also protects because they're both exempt for the same purpose. So you still get to receive those SSI, Medicaid benefits. Regarding transfers, John also mentioned earlier that there's one benefit called housing. It's called housing as a qualified disability expense. In the trust world, when somebody's receiving SSI, if you pay for certain what they call shelter expenses, which are the same thing as housing, you may have a reduction in a person's SSI benefit. And it could be substantial, up to 1/3 of the full amount that you can receive from SSI, which is $783 this year. So as a result of that, using an ABLE Act account, you can make transfers from a special needs trust, Social Security has permitted this, into the ABLE Act account, and it will not count against your child or loved one or yourself living with a disability against your benefits. So they've said that that's kind of an exempt from being counted as income. And then once it's there and you use those same funds for those same housing or shelter expenses, what we call in-kind support and maintenance, it does not cause that same reduction in the benefit. So they get to keep the full amount, that full $783, as long as they're using it before the following month, as John mentioned earlier also, because then it becomes a resource. So generally speaking, that's a way, again, not only to couple things together between a special needs trust and a ABLE Act account, but it promotes additional flexibility so that the beneficiary has more control over his or her own SSI payments and what it's utilized for. And they get really the best of both worlds as a result of that.
Awesome. So,
Rachel,
John,
can I add something?
You can, absolutely.
Yeah, so, I think this goes back to what Stephen and Melissa were talking about. And I think when ABLE accounts first came out, some people thought that this was going to replace special needs trust. And that's not the case. Mostly that's not the case. And so usually they can work hand in hand together. I think often of ABLE accounts is being able to put money aside now. Like I have $25 a month I want to be able to save for tomorrow or for some purchase. While a special needs trust is really part of the whole idea of estate planning. It's thinking of, I have a loved one, I have life insurance policies, homes, vehicles that I want to be able to say if something happens to me, that all these assets can be used to continue to support that loved one. And so I think it's a different kind of, they belong together, they work in sync together, but they are two different products.
Absolutely. And John, I want to stay with you here. So I want to go back to the basics a little bit. So how do you request or withdraw money from an ABLE account?
Yeah, so with an ABLE account, envision like an online savings or checking account. You would go on, you would log in with a user ID, your email address, a password. There's a transfers tab and say, hey, I want to be able to withdraw from one of my investment options or savings options. And usually that goes to the connected account. So usually you connect a bank account, whether it be a checking or a savings account online, and then you would distribute funds back to that account. Or you can request a check to be sent to yourself or to a third party. So for example, if you had a mortgage payment and like Melissa was saying, you wanted your ABLE account to pay that directly, you could request a check to be sent directly to that landlord or to that mortgage company to be able to pay that. So it's unique that it's mostly done online, but we also launched one of our more flexible tools is our ABLE Visa prepaid card. This is a prepaid card that can be used anywhere Visa is accepted. This is actually run by TrueLink Financial, which has done a great job helping people to get access to their funds. So there's some additional securities with it, but allows a little more flexibility to be able to load that card from the ABLE account and then use it wherever Visa is accepted.
So talk a little bit about the distributions, John. What types of purchases can an individual make with an ABLE United account that they can't make with a special needs trust?
That's a good question. I mean, let's talk a little bit about, one way is to allow an ABLE account if you're on SSI to pay for housing-related expenditures without reducing your SSI benefits. But you can also pay for food and groceries. Basic living expenses can be used as well. And really, it's anything that's going to relate to that individual and help improve their health, independence, or quality of life. So it could be short-term kind of savings goals where you're like thinking, I want to go to school next semester, I want to purchase some kind of book. It could be a modification to a home. It could be assistive technology. So I want to use an iPad to help me navigate my community. So a cell phone or cell phone plan would be a qualified disability expense. So it's pretty broad. And I think, Melissa, correct me if I'm wrong, or Stephen, correct me if I'm wrong, but I think special needs trust can also be used for a lot of variety of types of expenditure, but there's a little bit of a process to be able to get those funds distributed.
Yeah.
Well, technically, if I may, well, go ahead, ladies first. Go ahead, Melissa.
Sorry. I was just going to say that's true. It might be a process, but also going back to the whole purpose of ABLE Act accounts. And even when we have a special needs trust, we want to see our beneficiaries flourish, right? And do as much as they possibly can on their own. So having a TrueLink card even, whereas, outside of an ABLE Act account, if you had a prepaid debit card, so to speak, it might count differently against your benefits and create a problem for that. So again, it promotes independence. There's been times also, just to give a quick example, in a first party special needs trust situation, you can't really make gifts to anybody. And I always have people coming to me saying they want to give a little holiday gift to their teachers, for instance, at the, during holiday time. Well, maybe I shouldn't be saying this out loud, but I think that there's one qualified disability expense that's general health and welfare, well-being, and really it's a psychological benefit for the individual to be able to do that. So whereas we might not necessarily be able to do that from a special needs trust, you could do something like that from an ABLE Act account and still have it considered that. I've also had alternative medicine, I'll call it that, where certain things can't be paid for with anything but cash. So we've been able to fund things that way, even though they can't get out, we can give that to another individual through a card like that, through the ABLE Act account, and allow them to be able to get their alternative medicine. So those are a couple examples. And I think Steve's going to go through another one in a few moments. That's important.
Yeah, well, you hit pretty much everything I was going to say, Melissa, but I did want to comment on to follow up on what you were saying and then add another. The rules for a special needs trust, in particular a first party special needs trust, in an ABLE account are different. ABLE accounts have a broader definition of what is an allowable expense from the account, called qualified disability expense. First party special needs trusts have what is known as the sole benefit rule, which guide the trustee in making distributions so that they're not violating the beneficiary's public benefits eligibility. As Melissa mentioned, the idea of gifting or tithing to the church or anything of that nature, generally not allowed in a first party special needs trust because it's a gift, and gifting is not allowed. Right. But as Melissa described, I mean, it could very easily be categorized as a qualified disability expense under probably 2 or 3 different categories. So there's a broader opportunity there in an ABLE account. And as was touched on with regard to housing expenses and the purchase of food and things of that nature, and I want to go just slightly away from special needs trusts for the moment and talk more generalities of eligibility and the opportunities that other people have to provide for someone for a loved one's benefit and use an ABLE account to do so. I get a lot of clients that come in and they have let's say they have a child with a disability who's on SSI and living in the community and has rent and food expenses and all those typical expenses of life. And the parents say, well, my child only gets $783 a month. I've been supplementing I've been putting money in their bank account. I've been paying their rent. I buy them food. They, in those types of things. All of which are, if it comes directly from the parent to the loved one, can be disqualifying. You can't give cash to an SSI recipient. You shouldn't be paying their rent or buying them food, because that's, as Melissa described, was disqualifying as in-kind support. If that parent or loved one takes that same money and puts it in an ABLE account And then the ABLE account makes those purchases, as John was talking about, it's not disqualifying. So I saw a lot of folks were not terribly familiar with ABLE accounts, and maybe they weren't familiar with special needs trusts or don't even have one. I wanted that to kind of expand that to, it's not just special needs trusts and ABLE accounts that have that opportunity. It's parents, friends, siblings, whomever that want to provide financially for an individual with disability on a needs-based program such as SSI. That ABLE account is a great opportunity to maximize that benefit that they're providing.
Right. And I want to stay kind of on the same topic, Stephen. So can you explain how an ABLE account can continue to benefit the beneficiary after, say, a parent or a legal guardian passes away to pay for things while an estate or trust is being settled?
Well, kind of a two-pronged question there. The ABLE account continues because it is owned by the beneficiary. And if a parent or guardian was the authorized agent on the account, and perhaps the beneficiary doesn't have the ability to access that account directly due to mental inability or whatever, another agent is going to need to be immediately put into place, be it a successor guardian or a new designated agent or power of attorney or whatever, to be able to access that ABLE account. But that ABLE account continues on during the pendency of the estate of the deceased parent, let's say. But what cannot happen is the ABLE account can't be used to pay the expenses of that deceased parent's estate. It is only for, I mean, there are limitations on what an ABLE account can be used for, and it is for the benefit of the beneficiary, not the benefit of the beneficiary's, parent's estate, their guardian's estate, or anything like that. So, there are some limitations, but if we keep our eye on whose money is it, it's the beneficiary's money, and who can it be used for, the beneficiary's needs, then that can continue regardless of some unfortunate event where a parent has passed on or the guardian has passed on. That account is there and is still available.
Right.
If I could add something to that. So I see it oftentimes where families have a trust document, even some attorneys, not elder law attorneys necessarily, but other attorneys, when they're doing planning, they're focused on tax, estate planning, maybe even including a special needs trust in your plan, but they're not thinking about the personal side of things necessarily, unless it's really a good holistic discussion that you're having with that attorney and maybe your other advisors. And I think that's an important point to bring up here, because people don't realize that it can take 6 months, sometimes up to 2 years, to settle an estate through a probate process in court, or even to settle a trust document, depending upon the circumstances, of course. So I often recommend ABLE for that very reason as well. Of course, talking to people like John and Rachel at ABLE United to understand that a little bit more, but because they have that flexibility again, that added continual flexibility, that plan that you need to have in place for what's going to happen if something were to happen to you and you have a child living with a disability. You're thinking about the personal and the financial, and those two go very well hand in hand. So,
and I want to make an additional comment, Rachel. First of all, I want to give a shout out. There's a lot of questions coming in, so keep them coming in. We probably won't be able to get most of them answered on here, but we will do our best to follow up with you individually. But with that, I saw a lot about what kind of records or record keeping is required when you're making a withdrawal from an ABLE account. And I don't know about special needs trust, so that'd be good information for me. But I know when it comes to an ABLE account, we usually tell people, hey, keep receipts and a note of why it's a qualified disability expense. How does that relate to that person with the disability that owns the ABLE account, and how is it benefiting their life? Why is it a qualified disability expense? We're not going to ask for it as a program. There's no pre-approval process. But if the Internal Revenue was to ask, or if you're on SSI, Social Security could ask, saying, hey, show us documentation on why that's a qualified disability expense. So that's interesting to know. But to Melissa and Stephen, what is it from a special needs trust? Is there documentation when a withdrawal is made that needs to be kept or recorded for either IRS purposes or other purposes?
Go ahead.
Okay. So as as a trustee, working for a trustee, we do require that there be some documentation for the request itself to begin with. So we want substantiation and understand that if we're going to be doing a transfer from the trust, we have a duty to do that under the document, of course, but to make sure it's for a qualified disability expense. And we get upfront information for that so that we know what it's going to be utilized for. So that could be estimates, it could be receipts, it could be from past bills that were paid, if it's related to housing or something like that. And we do keep that in our file. But once our discretionary decision is made to do that transfer to the ABLE Act account, we as a trustee, whoever is the trustee, whether it's a corporate trustee or a family member that's a trustee, or a friend for that matter, an attorney or CPA, they don't have any legal authority over the ABLE Act account. It's separate. Just as if they don't have legal authority over the government benefits either, but only what's within the document and what's invested in that trust is what they have control over. So we often are absolved from liability for what happens after the transfer is made to the ABLE Act account. But of course, we meet our duty to make sure that what it's being transferred for first is appropriate under the standards of the document.
And let me follow up on that as to reporting to governmental agencies. In Florida, there is an administrative rule that requires any first-party special needs trust to be reported quarterly to the Department of Children and Families. All distributions and all money coming in and all money going out of the account has to be sent in, and not necessarily a formal accounting, but that information has to be delivered to the Department of Children and Families quarterly. Any special needs trust, first or third party, needs to be reported to the Social Security Administration at its inception, when that becomes available to the beneficiary, or when the beneficiary is asking for benefits, for analysis as an exempt resource. But also, Social Security has the right to ask for an accounting of the trust from the beneficiary to show whether or not disqualifying distributions have been made, such as in-kind support distributions or direct cash to the beneficiary or something of that nature, to calculate whether or not the SSI recipient has received the correct amount of SSI throughout that time frame. And sometimes they come back with an overpayment or something if there's been a disqualifying distribution. Now, I didn't ask John this question prior to the conference, so I'm throwing this one out there blind. ABLE, as I understand, is required to send accountings to the Social Security Administration on a periodic basis. I don't recall how often, but I'll let John speak to that.
Yeah, great lead in there, Stephen. I appreciate it. But yeah, so as a state and as an ABLE program administrator, we're required to submit monthly to Social Security Administration all transactions on account. So what they're doing is they're taking that data and they're reviewing and seeing, okay, of these accounts, which individuals are receiving supplemental security income, SSI, that monthly check. And what they're doing is saying if there was a withdrawal from the ABLE account, they will reach out to an individual to say, hey, we see that you took, $500 out of your ABLE account. What was it used for? And they're primarily looking to say, okay, was it a qualified disability expense? And if they're retaining it, so it's part of their bank account now, that it is accounted for and what it's going to be used for. So if it's going to be for a future housing expense, that could impact their benefit. But if it's going to be used for an upcoming medical procedure or maybe a vehicle purchase, they know to exempt that from their $2,000 resource limit. So that's from the Social Security standpoint. From the IRS standpoint, since these are tax advantaged accounts, we do submit to the IRS on an annual basis, and you'll either get one or two forms depending on how you use your ABLE account. The 5498 QA is just a basic accounting saying, hey, you have an ABLE account, it's established, here's how much money is in it. If you do make a withdrawal from your ABLE account, you'll also receive a 1099 QA, and that tax document is showing, hey, you had an X amount of withdrawals from your account. Of that, how much of it was earnings? And then as long as you didn't have any non-qualified disability expenses for the entire year, or you say, hey, I had $3,000 in withdrawals and I had $3,000 in the qualified disability expenses, then those earnings would be tax-free and there's no taxes on it. But those are the documents you may receive depending on how you use your ABLE account.
Awesome.
Rachel, if I could add one thing there, because I don't believe it was mentioned earlier, and that is that, John, you talked about, I believe, the amount that you could put in the ABLE Act account annually at $15,000. But I'm not sure if I heard you mention that individuals who are also working can put in their funds from employment as long as they don't have a different retirement account, which most often is not the case, but it's important to think about that if you're going to be getting a job or you have a child that's going to be working, and you could put an additional amount in there. I believe it's $12,490 if I'm not mistaken. I might be off on that number a little bit if you can confirm that, John. Okay, and so that's important. It's still, the income still counts under normal income when you're working, and it counts typically half, and there's a couple deductions like, an allowance that you can also keep, but usually it counts by half, against your SSI. It might lower your SSI when you're working, but it may not deplete it completely. And so that's just another important thing to understand. With that, I'm just going to caution you also that you also have to be aware of the substantial gainful activity number that's tied to the definition of disability, because $12,490 may be actually over that amount or close to it, where you would not be considered to be disabled any longer as a result of that. And of course, there's other programs available through Social Security, the Ticket to Work program and things like that, where you can expand on being able to work and have particular programs and protections in place there as well. So I thought that was a good time to add that.
Yeah, Melissa, and I want to comment to that, and I think that is a good point, because often, we're starting to see this question more and more. If I'm not on government benefits, why would I have an ABLE account? Maybe it's somebody that is gainfully employed. They're not going to be on public benefits anytime soon. Why would I need an ABLE account? And I usually tell people it's the benefits of the tax-free earnings, right? If I could contribute $10,000 and make 5% in a calendar year or even a quarter, that's money making money, and we all like that and not have to pay taxes on that. So I think there's a flip side of the coin saying, hey, if you're able to be fully employed, you can really use ABLE account as an additional retirement account or something to potentially have your money go further.
Right. Yep.
So I want to go back to Melissa, because this is another thing that we oftentimes get questions about, and I want to address Medicaid recovery. So Melissa, can you share a little bit about why that comes up in conversations about special needs trust?
Sure. As Stephen mentioned earlier, there's basically two different kinds of trust. The first party special needs trust, remember, that's the person's own funds. Usually you see that as a result of a car accident or medical malpractice action, some type of lawsuit recovery, or when people have not set up the appropriate special needs trust, to make that available and leave funds outright to their child or loved one. So it's important to understand that distinction. In a first party special needs trust, there is a payback at the beneficiary's passing for whatever Medicaid has paid out for them for their lifetime. Whereas in a third party special needs trust, because it's funded by a third party, once again, usually a parent or grandparent, but it can be done in other ways as well. And there is no payback provision. Now let's move over to the account, right? The ABLE Act account. The ABLE Act is an account. It's not a special needs trust. So they're under two different areas of the law on how they were created. So with ABLE, there is a payback provision for Medicaid only, again, after the beneficiary passes. However, the state of Florida has stated they're not going to go after the funds in ABLE for, the savings that have accrued in the ABLE Act account after a person's passing, but it also still goes to the estate. So that means the beneficiary has to be the estate. It cannot be anybody else designated under the account ownership documents or anything like that. So because it goes to the estate, in Florida, if you're over the age of 55, you have to notify Medicaid, and Medicaid can recover. That's Medicaid estate recovery. So even though Florida has stated they're not going to go after ABLE Act accounts from that standpoint of a claim on the money, if the beneficiary dies, again, of the ABLE Act account, it has to go through the court proceeding, the probate proceeding, for it to be then distributed out to anybody, and will be subjected to that recovery through Medicaid if they're over the age of 55 when they pass.
Let me, if I may, I want to tie into Melissa's comments. The differences between a first-party special needs trust and an ABLE account at passing. With a first-party special needs trust, as Melissa was saying, there's the Medicaid payback provision, mandatory Medicaid payback provision. Until, well, let me preface it by saying, until Medicaid is paid back, there are very, very few items that can come out of that first-party special needs trust. I should say, until Medicaid is paid back. Essentially, the trust is on lockdown. Until the Medicaid has come back, they come up with a lien, that lien's been paid, and then the assets are freed up. That takes months. An ABLE account, by law, is able to pay other types of expenses after the death of the beneficiary and under the federal law before the Medicaid payback. As Melissa said, Florida's not even enforcing the payback, it goes to the estate. But even before it goes to the estate, there are things that could be paid out of that account, such as a burial. And that's the most common scenario I come across, is someone with a first-party trust passes away and they've not prepared for their last disposition, their funeral, their remains, etc. A first-party special needs trust cannot pay those expenses. It is on lockdown, and that is a specifically forbidden expense from a first-party trust prior to Medicaid payback. That is not the case for an ABLE account. I'll let John speak to how that process works if he cares to, from the administrative side, but from the legal side, it's a significant difference in the availability of and benefit to having an ABLE account along with a first-party special needs trust is that things can happen after the death that can't happen solely from a first-party trust. So, John, do you have anything to add on that?
Yeah, actually, about a week or two back, I did receive a written request where a beneficiary had passed away and they had some outstanding funeral costs, and so we were able to send a check directly to that funeral home to pay for those outstanding costs from the ABLE account. And so usually for us, until we're notified that the beneficiary has passed away, it's business as usual, and we're assuming that the administrator or whoever is overseeing that ABLE account is continuing to do their due diligence in managing the account. But once we are notified that a beneficiary has passed away, we do note that account. And then, we're in the process of trying to say, hey, get these funds out, close the account, do whatever. But that's usually how it typically has worked.
Right. So I do want to spend just a few minutes talking about advanced directives. Melissa, do you want to take that one?
Sure. So I mentioned earlier that you have a durable power of attorney for property, and the durable power of attorney for property, basically the person who's actually asking for that, you're appointing an agent for you to make decisions on your behalf. It's immediately effective in Florida when it's signed, and that usually deals with the financial components of your life, everything from contracts, real estate. It can also include many different items that you have to specifically initial off on, but inclusive of government benefits and potentially even opening an ABLE Act account. So having that provision added to your durable power of attorney is an important provision to have in there. But again, as I said earlier, that might be an authorized signer. It's a less restrictive alternative. It goes back to that holistic point of view, right? Just because a person's living with a disability, it doesn't mean they need a guardian or a guardian advocate. Maybe he or she has capacity to enter into that document and designate somebody else to help them make those decisions or make those decisions for them if they are no longer having capacity to do so. And then the same thing holds true on the healthcare side, is the healthcare surrogate in the state of Florida. And there's also a living will. I wasn't going to go into that in too much detail because I think that we were mainly concentrating on the durable power of attorney and how it can relate to the ABLE Act account and special needs trusts.
Awesome. So Stephen, we're getting a lot of questions in regards to reporting. So say if I'm a guardian of a person, do I still need to report the Able United account since I have a first party special needs trust?
Well, to be honest with you, I'm not quite sure who you're asking me, do you have to report to? Is it to the guardianship court, or is it to the trustee, or since the Able account and the trust are two totally separate things and totally separate empowerments, they really don't relate to each other legally. They're as I said earlier, the Able account's owned by the beneficiary, special needs trust is held by the trustee. If we're looking at whether a guardian, you said guardian of the person, they don't have the financial ability, the ability to deal with finances. So they're really not going to report anything with regard to financial matters. But if we have a guardian of the property, let me go there, and that's a question I get frequently. If we have a guardian of the property and that beneficiary has an Able account, it's an asset of the beneficiary, owned by the beneficiary, and thereby legally under the control of the guardian, presuming that the guardianship is of the property. Some courts in the state mandate that Able accounts be accounted to the court as part of an annual accounting. Other courts in the state, and I'm giving you the it depends answer, that's a typical lawyer answer. Other courts in the state are saying Social Security is looking over this, Able United is managing it. It's analogous to a trust, but even though it's not a trust, so we don't need you to account to us in the guardianship court. My answer to the overall comment, question really is, if you have a guardianship and an Able account, check with your guardianship attorney to understand what your reporting requirements are going to be to your court. Because you do have to report, as a guardian, typically you have to report to your local court, your circuit court, unless that's waived. And sometimes it includes the Able account and sometimes not.
Awesome. So another question that we're getting quite a bit is, how much does it cost to start and manage a special needs trust? And I know that answer is probably going to be based on the situation, but Melissa, Stephen, we'll let you guys kind of tackle that one.
Stephen, why don't you go first there?
Well, I'll talk to the starting. A special needs trust is a fairly complex document, as Melissa was alluding to. All the terms have to be in there and the direction to the trustee and everything. You will see attorney's fees all over the board. I'm not going to quote numbers, but there is lawyering and legal fees involved in the creation of a, and I'm getting echo somewhere, I apologize. There are fees involved in the creation of a trust. It's legal work, and that is what it is. I'll let Melissa comment on the administrative expenses of a trustee, et cetera. And then I suppose John would comment. I know you didn't ask the question. I imagine John's going to comment on the expenses involved in creating an Able account.
Well, I know, Rachel, there was another question about what happens if the trustee passes. So they kind of correlate with one another. So I'm just going to answer from that standpoint also. So when it comes down to the trust, like I was saying earlier, I'm hearing feedback also, by the way. It can be an individual acting as a trustee, it can be a family member, it can be a friend that you trust. Obviously, there's a lot that goes on in the special needs trust, so you do want somebody with expertise if you can. So usually, that would most likely be an attorney. Now, every corporate trustee has different minimums as to when they will act as a trustee. They run across the gamut there. So I'm not going to really tell you what those are, because there's so many different answers to that question, and kind of the way there is the answer to what attorneys charge for creating the trust. However, there are different types of trust vehicles also. That one of them that was not mentioned, that's a pool trust. And a pool trust is basically established and managed by a not-for-profit organization that's under a different section of the laws also. It can be first party or third party money as well. They can separate it out and it gets invested differently. In those cases, if it's not a larger sum of money that you're talking about, and it may not be cost effective for you to have an attorney, depending upon what that attorney is going to charge, of course, to actually draft a separate trust document, it may make sense to join into a pool trust. And there's some other benefits that I'll let Stephen go into regarding a pool trust and what happens to funds after a person dies, since we mentioned Medicaid recovery earlier. But just understand that there are also some private fiduciary companies out there that also act. My thought is that you should talk to your advisor, either your attorney, your CPA, or even, you know, some other individual families that you're aware of, because parents are usually the best resources for one another, to find out references, and always get 3 references. And then you can look towards those people to make the most appropriate decision for yourself and your family.
Awesome.
I was going to touch on ABLE fees. I know that was a question. So ABLE United is very fortunate that we're basically almost free. I mean, there is no monthly account maintenance fee. There's no setup fee. There is that minimum $25 contribution when an account is first opened. But after that, it is a minimum $5 contribution when you choose to make a contribution. We do have investment and savings options, and depending on which one you select, there is a underlying what we call an investment administration fee, but those are pretty low. And then there's also those special fees. So if you needed like an overnight check, or you had an insufficient fund transfer or something of that similar, there's some fees tied to that. But that's generally, we try to pass on the savings that the state has to our participants.
And can I just add one other thing to the question about when a trustee passes? So oftentimes people put what they call a catch-all provision in there for what would happen to their assets if there was nobody left after them, right? And hopefully a charity. But you should also be doing the same thing when you're designating different people in different roles. And one of those is a trustee role. So somebody had asked the question about what happened if the person that was named in the document passed away. So you can have a corporate trustee as a catch-all provision. It could also be a pool trust company as a catch-all provision. You don't specifically need to name the pool trust company unless you want to, obviously, but there's certain other things that would go in there that the attorney would know should be in the document if that was the case. So that, most corporations, not every one of them, corporate trustees, the ones that do have specialization in this area would be the key ones to at least look into before you determine who you're going to name in the document. And that's when you can obtain that additional information.
Awesome.
Let me just say one thing as to the selection of the trustee that wasn't said today, and may not be self-evident, is that the beneficiary themselves cannot be the trustee. They cannot have direct access to those funds in the trust, because that is a requirement of any special needs trust. I've said several times that the ABLE account is owned and managed and accessible directly by the beneficiary, but the beneficiary for the ABLE account, but in a trust, the beneficiary cannot be the trustee and cannot have direct access to the funds in any way.
Awesome. Well, I know that we could probably sit here and talk for another hour. So before we conclude, I'd like to open it up to each of our panelists for any last words. So Stephen, what's the #1 piece of advice you find yourself giving for individuals planning for the future?
Explore all your options. There's no one, Batman doesn't have one tool in his utility belt. And, I know that's kind of maybe a cliche comment or a bad comment for some folks who don't know Batman maybe, but an ABLE account is a great tool. It has its limitations like any tool has, but combined with the special needs trusts and other opportunities, it's a great fit into the mix, and it should always be explored as an option, to be honest with you.
Awesome. Melissa, same question.
Yes. I would say the most important thing is really having a holistic approach to planning, including the special needs trust, the ABLE Act account, but even more so, making sure that you're sharing the information with whoever you're designating under documents, whoever you're naming, whether it's a power of attorney, a trust document, as somebody that's going to be a potential future guardian for your child or guardian advocate, to make sure they have a good understanding of the personal side of your child and that you're doing that personal planning early on. Can't stress that enough, rather than when that crisis situation occurs. And then that's going to be more impactful in a negative way, unfortunately, on your loved one living with a disability. But by doing it ahead of time with all the advisors that you should have as part of that process, I think you'll be doing the best that you can to set up the plan for the future of your loved one.
Awesome. So John, any last words on why those attending who don't already have an Able United account and why they should consider opening one?
Yeah, and I think we talked about many of these points on just the accessibility, the ease of use, and going back to the question you asked Stephen and Melissa is future planning is to get started, start today. You know, and I think that's what's beneficial with even an Able account. It takes 15 to 20 minutes, and just to say, hey, I'm gonna start doing something, and that's an easy place to get started at is to open an Able account. And I know there's a ton of questions that have come through, and we weren't able to answer them all. But I just want to thank everybody too. Thank you, Melissa and Stephen, for joining today's call. I think it was very beneficial, and hopefully we'll be able to do this again in the future.
Yeah.
Thank you for having us.
Echoing the panelist sentiment, knowledge is power, and we are so appreciative to each of you for taking your time out of your mornings to discuss this really critical topic. So if we didn't address your specific questions during today's roundtable, please feel free to reach out to us at info@ableunited.com, and we'll try to answer as many questions as we can. Additionally, for those who may not have an Able United account just yet, I encourage you to visit us online at ableunited.com to learn more. And most importantly, enroll, because we are running a very special promotion until September 30th. So for anyone who opens up a new account, completes enrollment online, and contributes that minimum contribution of $25, Able United will put a free $50 in the account to help you get started saving. We're also running a special giveaway on our Facebook page for current and prospective account holders, where all they have to do is share what they're saving for with Able United to be entered to win a brand new iPad. So thank you all again for joining us. Until next time, we'll see you then. Bye-bye.
Bye-bye.
Thank you all.
Bye.